Ready? Start. The Gujarat High Court's view noted above, if accepted, would mean that though the son of a predeceased son and not the son of a son who is intended to be excluded under Section 8 to inherit the latter would, by applying the old Hindu law, get a right by birth of the said property contrary to the scheme outlined in Section 8. Furthermore, as noted by the Andhra Pradesh High Court, that the Act makes it clear by Section 4 that one should look to the Act in case of doubt and not to the pre-existing Hindu law. It would be difficult to hold today the property which devolved on a Hindu under Section 8 of the Hindu succession would be HUF in his hand vis-a-vis his own son, that would amount to creating two classes among the heirs mentioned in class first, the male heirs in whose hands it will be joint Hindu family property, and vis-a-vis son and female heirs with respect to whom no such concept could be applied or contemplated. It may be mentioned that heirs in class first of schedule under Section 8 of the Act included widow, mother, daughter of predeceased son, etc. The express words of Section 8 of the Hindu Succession Act 1956 cannot be ignored and must prevail. The preamble to the Act reiterates that the Act is inter alia to amend the law. With that background, the express language which excludes son's son but included son of a predeceased son cannot be ignored. This question has been considered by this court, where one of us observed that under the Hindu law, the moment a son is born, he gets a share in father's property and becomes part of the co-parency. His right accrues to him not on the death of the father or inheritance from the father, but with the very fact of his birth. Normally, therefore, whenever the father gets a property from whatever source, from the grandfather or from any other source, from the grandfather or from any other source, be it separated property or not, his son should have a share in that, and it will become part of the joint Hindu family of his son and grandson and other members who form joint Hindu family with him. The court observed that this position has been affected by Section 8 of the Hindu Succession Act 1956, and therefore after the act, when the son inherited the property in the situation contemplated by Section 8, he does not take it as katra of his own undivided family, but takes it in his individual capacity. This court observed in the aforesaid decision that the views expressed by the Allahabad High Court, the Madras High Court, the Madhya Pradesh High Court, and the Andhra Pradesh High Court appeared to be correct and unable to accept the views of the Gujarat High Court. In that view of the matter, it would be difficult to hold that property which devolved on a Hindu under Section 8 of the Hindu Succession Act 1956 would be HUF in his hand vis-a-vis his own sons. If that be the position, then the property which devolved upon the father of the respondent in the instant case on the demise of his grandfather could not be said to be HUF property. If that is so, then the appellate authority was right in holding that the respondent was a licensee of his father in respect of the ancestral house. By way of this appeal, the appellant seeks to impugn the order dated December 13, 2012, passed by the learned single judge dismissing the suit of the appellant for partition and redemption of accounts. The aforesaid suit was filed by the appellant Master Sushant Minor through his natural guardian and mother against his father Sri Sundar Sham Singh, the respondent herein. The appellant or plaintiff has averred in the plaint that the respondent or defendant received by devolution various movable and immovable properties enumerated in the plaint from his father, late Sri Joginder Singh, grandfather of the appellant or plaintiff, who died on 14/11/1999, and therefore he, the appellant, became a co-possessor and entitled to the share from the properties which had been inherited by his father, the respondent number 1, from his grandfather, late Sri Joginder Singh. On the aforesaid facts, the learned single judge, while the impugned order rejected the plaint under Order 7th Rule 11 of the Code of Civil Procedure on the ground that the plaint did not disclose a cause of action. Source is 3P Legal RHC and exercise number is 50. Words are 760 and speed is 100.